Good morning. Welcome to our first day of our April call. Our first case is, one second. Our first case is Bradley versus Frye-Chaiken. This is a 15-minute mini oral argument on the application. You may reserve time for rebuttal, but we ask that you keep track of your own time and you can begin when you're ready.
May it please the court, Barry Powers, in a dual capacity, appearing both for my client, Linda Frye-Chaiken, who has ever since I met her asked to be referred to as Linda Frye instead of Linda Frye-Chaiken, so with respect I will ask to do that. And I'm also in the unique, as I mentioned, dual capacity, not only of representing Linda here, but also myself, pro se. So I believe my appearance is hybrid. My duties are to this court, all courts of the state of Michigan, to the public, and to my client. I believe the way that your honors have addressed the MOA, the request for briefing, and some argument, some limited argument on the application, excludes those particular parts of the case pertaining to Linda. However, one thing that kind of merges is the principle that there must be findings of fact, and there is no joint and several liability, but it's fair share liability. So I'm going to start the way I finish. My requested relief is not only that this court grant leave, not act on the application in any other way other than granting leave to make full argument as a calendar case, with your honors giving the matter full plenary treatment because of the grave and really scary nature of the way this area of the law, not this case, the area of the law has come to be. And may I belatedly ask to reserve 3 minutes of time for rebuttal?
Yes.
So I can't ignore, even though I have my own interests to protect, that I'm also here as a member of the bar, and I'm very honored that the way that this court has put the questions to me, I felt it my responsibility not only to protect my client, Linda, and my own interests in my law license, not to mention my rights in this appeal, but also to do my best to examine my conscience, what it means to be a lawyer. I've been practicing law in the state for 37 years, continuously, with an impeccable record until now. And there's $16,000 at stake, 4 lawyers and 1 client. I suppose I could have said, let's the 5 of us sit in a room and just divvy up the $16,000. To me, $3,000, $4,000 is still a lot of money, but I'm sure your honors can understand that representing myself in this case, I have not been able to ask for compensation or whatever, think of it, nor would that be proper. So certainly, if, in terms of hours and so forth, I'm sure your honors can understand that maybe I not only have a passion for the question, and am so grateful for the opportunity to address this court, and I certainly can't do it adequately in 15 minutes, but also to try to speak, at least from my own personal perspective, on what I believe is my obligation to do the best that I can. Now, I hope you understand my passion, and my passion is really not an issue. However, I want to get back to Linda. She's a person that is approaching age 80, and she's a holder of several master's degrees in music from the University of Michigan. And she was getting scholarships to pursue master's degrees, and they were successive. She pursued 3 master's degrees on in music at the University of Michigan, and finally somebody found out about it and said, well, you know, you can't have any more master's degrees. So she's a wonderful person. I think one of the real tragedies here is, in my opinion, and again, I'm not speaking on the adequacy or inadequacy of how my predecessor counsel handled the case. That was not my province, and I've never been asked to do that until the Attorney Grievance Commission put me under investigation for why I didn't report their misconduct. So I am today before this court under the investigation of the Attorney Grievance Commission. Mr. Getz, the commissioner, sua sponte, took it upon himself to investigate me because apparently I, instead of throwing in my $5,000 or $3,000 in the kitty and ending it and moving on, because I challenged this in the Michigan Court of Appeals. My predecessors didn't challenge it. Mr. Carey, who I think is similarly situated, he didn't challenge it. And certainly I can't ask whether the Honorable Andrew Fink is being under investigation, because the question is, why didn't I report my predecessors? I wonder if the Honorable Mr. Fink is being treated the same way, or whether the judge, the trial judge, who observed this apparent frivolous conduct is being under investigation. Luckily, while I was handling the appeal for Linda, 11 months later, this decision came out, which obviously drives a wedge. I'm in the middle of representing her in the Court of Appeals. Well, this drives a wedge now because I went to Linda and I said, well, I believe at this point now I guess I'm a party to the case. So you and I guess, are now parties, even though I never had my first right to be heard. My first right to be in court was in the Court of Appeals. But at any rate, I said, we got along great. Everything was fine between her and me. In fact, I didn't want to handle the evidentiary hearing. She hired me for the appeal. I said, Mr. Carey is fine. He can handle it. I don't want to do the evidence. No, she insisted on it. So that was a toenail. I'm sorry, that was a hangnail. But in any event, I went to her and I said, well, I want to let you know you could sue me for indemnification, because her having 4 other pockets instead of just 3, it benefits her to be on the hook, I suppose, theoretically. And I said, I suppose I could sue you for indemnification because I didn't do anything wrong and it's up the chain. But of course I'm not going to do that. So I said, unfortunately, now you don't know the law, so if a judge holds me liable for doing something, to her, my integrity now is in question. So I said, I'm afraid the only thing I advise you to do is get your own separate counsel as to whether it's proper for, whether it's putting you at risk, more vulnerable. And I suppose this is a conflict that you may waive.
Counsel, good morning.
Good morning, Your Honor.
Good morning. Just a quick question for you. What would you like this court to do? How would you like an opinion to read?
I would like this court to address the common law of the state of Michigan. The American rule, as we all know, is that each party bears his or her own share of the attorney expense, whether or not that party prevails. And I was going to ask that we review the fact that statutes and rules in derogation of the common law are to be narrowly construed in the first place. I don't believe that this court, in promulgating Rule 1.109, or the Michigan legislature, in promulgating Section 2591 of the Revised Judicature Act, intended this result. I was going to ask this court to acknowledge that an attorney who has the privilege of being granted a license by this court, a law license to practice law, which in my mind is close, it's not sacred. I'm a Catholic, and I think if I say sacred, that means we're on a higher level. So I don't want to be too pompous. This is a high level, but I can't think of a word other than it's as close to sacred to be a temporal thing of this life than it is. And I cannot think of any better way for a human being to spend the life that he or she has on this planet other than to practice the law. I cherish it that much. I'm in the middle of a trial right now. We started it yesterday in front of Judge Warren in Oakland County. He scheduled it for today as well. I had to get permission to get Mr. Royster to call him, so I'm back in. And it's thrilling. And there's nothing more fundamentally satisfying than when that client puts his or her trust in you. There's nothing that's more serious. But I can't think of anything better to be a lawyer. And when somebody threatens my ability to be a lawyer, which I didn't know until I had this case, that I didn't realize I had a substantive due process right, property and liberty interest in my law license once I get it. And in this case, if this court lets these decisions stand, then they are construing both the Rule 1.109 and the statute in a way that is unconstitutional. And it's of that magnitude, and I think I've demonstrated that. So I would like this court not to act on the application other than to grant full leave. And I was intrigued by the case of Friedman versus Dozork. That's a 1981 case in and around the wake of the so-called tort reform. And again, I have to borrow from, we have something called the law of lawyering. I guess there's a treatise on it. I don't know if there is such a thing, but so you borrow from principles of tort law, I suppose. But in Friedman versus Dozork, the question was, can there be a cause of action for a lawyer who doesn't do his job right from the other side, though represented by counsel? And the Supreme Court took this very seriously. But the fact now that I'm here, and I think I've demonstrated that we are at a crisis point in what it means to be a member of the bar and of the bench. And this court, I think, unfortunately or fortunately, has an opportunity now to reform this area of law by decisional law. The third question had to do with what would you do? What would you have the court do to address this as a matter of adjudication? And I thought of the Miranda decision, where the Supreme Court, we all know, when I took constitutional law in front of Judge Grano at Wayne State, he said, well, that was really the Supreme Court legislating, writing a rule, writing a statute. How is it the Supreme Court can tell you what your rights are to your right to remain silent? But anyway, I sort of want to ask this court to do so, but in this case, it's certainly not inapropos. In fact, it's mandated because this court has rulemaking authority as well as decisional law authority, and there's so many other ways to go. So forgive me for focusing on Linda, but I just wanted the court to understand that I haven't forgotten her. It is my duty to acknowledge her in this process. The scope of this appeal does not really concern Linda, but to the extent that there's a sliver of her rights that are left, and I believe my briefing that there has to be findings of fact and conclusions of law, and not joint and several liability, but only fair share liability, means that as to Linda, who's to be treated differently than me, obviously, but this court should remand with instructions to the trial judge to look under 1.109 at whether Linda had any fault in this so-called frivolous cause of action or defense to a cause of action, findings of fact, and to the extent that there was any culpability on her part, that she be apportioned only that
I'm
part.
sorry, Mr. Powers, did you say you wanted to reserve some time?
Yes, Your Honor.
Well, you're down to 2 minutes and 30 seconds.
Thank you, Your Honor. Thank you. I want to fully answer the Justice's question. Thank you.
Good morning, Madam Chief Justice, and may it please the Court, Andrew Fink appearing on behalf of plaintiffs Appellees Eric Bradley and Jacqueline Chuang, and with me at counsel table is James Fink. Although this case is superficially about the attorney fee owed by one party and her attorney to another party, I think the core of the case is really about the duties owed by an attorney to his or her client, to the court, and to the bar. And unlike many of the cases that come before this court, the amount in controversy is relatively low, at about $17,000 total. And if my clients are successful at this court, they still may not ever collect anything from Mr. Powers himself because there are other parties subject to the judgment who could satisfy the judgment completely. And so in that sense, the stakes here are lower than in many cases before this court. But the public policy issues that are embraced by the Revised Judicature Act's assignment of attorney fees to both clients and attorneys, parties and attorneys who pursue frivolous claims or defenses are, of course, still very important. I think the primary policy aims under MCL 600.2591 are that we need the interests of an attorney and his or her client to be aligned. And by putting both attorneys and clients, attorneys and parties, as responsible for pursuing frivolous claims and defenses, the statute affects that alignment, which should encourage attorneys to push back on their clients who ask them to pursue frivolous claims or defenses. And a second public policy interest served by it is that when a party prevails in a case despite having confronted frivolous claims or defenses, by having both the attorney and the party on the hook for fees, the injured party, the prevailing party, may be able to recover from a second participant in the case, making it easier to be made closer to whole. So those important policy purposes are only served when the attorney is also on the line alongside the client. And I think that the precedents of this court and of the Court of Appeals especially indicate that even when attorneys appear successively and not arguing all at the same time, not participating all at the same time, joint and several liability alongside the client and the other attorneys may still be appropriate, at least when certain factors are met. The factors that are discussed in previous cases and in the lower court in this case, in the Court of Appeals in this case, include things like whether the attorney has appeared in court, whether the attorney has authored papers filed in the trial court, whether the attorney has had notice that sanctions are possible. Yes,
I
ma'am.
would love to just talk a minute about the amicus brief we received. It is not often we receive a brief from pretty much the entire Bar Association, plaintiffs, defendants, all sides of the equation. Do you agree with their assessment on what the law is, and you just think it should be applied? I think they're saying each individual attorney should be looked at for how they acted in the case. Do you agree with that or not?
I think that the sort of the test proposed in the brief by Miki and our brief, they're not terribly different, Your Honor. I mean, I do think that we both of us, of course, recognize that there's a constitutional requirement that any attorney subject to sanctions have notice and opportunity to be heard, for instance. I think we both say that a continuation of previous frivolous litigation could be a factor that should militate towards joint and several liability, including for successive attorneys. I do think the biggest difference is, frankly, a description of the record in the amicus brief that just doesn't comport with the record that we have. And so what happened in this case, I mean, the procedural posture here when Mr. Powers joined the case, and of course I don't mean to be standing up here being critical of another attorney, but these are the questions presented. The procedural posture was that sanctions had already been granted by the trial court. And so when Mr. Powers came into this case, that his client would be sanctioned, and that whoever the attorney for purposes of MCL 600-2591 would be sanctioned was already determined. And so who that attorney is, I agree with the amicus brief that answering the question of who the attorney is really the only issue to be resolved here, because if Mr. Powers is within the definition of the attorney under the statute, then there has to be some exception to the statute's general requirement that the attorney be part of the sanctions award. Now, where I think the amicus brief gets the record wrong is that the trial court found in its opinion and order granting the attorney fees that we asked for that Mr. Powers had attempted to relitigate issues that had already been settled in the case, that had already been litigated and decided in the case. And as I know you've seen in the record, Your Honor, the trial court used a variety of colorful language to describe actions by Mr. Powers once he joined the case, including saying that he was not kind of distancing himself from the frivolousness that his client had projected before, that the litigation had become ridiculous, arguments were ludicrous, silly, turning the court into a charade, into a circus.
But it was post-judgment, right? So I'm like,
It is, Your Honor,
taking
yes.
everything for what you're saying, the
Yep.
record speaks for itself. Obviously, he couldn't affect the judgment at that point, so they're just litigating the sanctions piece, correct?
Yes, Your Honor, but I think there's a very important part of the text of the statute that we have to pay attention to, which is that the statute says that the recoverable expenses by the prevailing party are the costs and fees incurred by the party in connection with the civil action. And there are other cases cited, I think really by all of us, including the amicus brief, where fees for post-judgment trial court litigation are included. I think that we could have continued, for instance, to ask the court to increase the amount we were asking for. I mean, one of the issues in the briefing is that the request for attorney fees was filed in like the late July or August of 2019, not decided until November of 2020. Obviously, some of that was the disruption of COVID and shutdowns and all that. But we still didn't have the hearing until January of 2020 before shutdowns. And so as these things continue to build up, I think we could have been amending the amount we requested and essentially didn't do that in order to keep the issue limited to the main thing, keeping the primary litigation the main thing. But I think under the text of the statute, litigation over the sanctions themselves are a part of the fees incurred in connection with the civil action, which is the language of the statute.
Wouldn't you have had to have moved for sanctions for Mr. Powers' conduct, and the judge would have had to have made a finding that it was in fact sanctionable, not just annoying or, anything else that the trial judge said? And my understanding, like, it could be included, but the reason why in order to impose liability on Mr. Powers for his conduct, you had to have moved for sanctions, and the judge had to have found that his conduct was, and that didn't happen on this record.
Respectfully, I disagree, Your Honor. The opinion and order of the trial court expressly found that Mr. Powers was subject to the sanctions and included that one of the reasons for granting that, and including Mr. Powers, was that there was an attempt to relitigate issues that had already been answered in the case. So respectfully, I think that the trial court pretty clearly articulated why Mr. Powers was a part of the joint and several award. But secondly, I don't think that
So a prior sum that had already been fixed and imposed against the client and 3 other attorneys.
The issue of sanctions had been answered, but not the amount, Your Honor,
Okay.
until the opinion and order was issued in November of 2020. I mean, it was the amount that we had asked for, but again,
Previously.
Yes, because when we filed our motion in August, knowing that there would be continued litigation, and I'll just say this as a matter of general practice, I've only sought sanctions in a small number of cases, but I've never continued to update the amount that I'm asking for, over the course of time. The client's never really made whole, even when they get all of the attorney fees back, and so I've never thought it was efficient on the client's part to continue to add as the sanctions litigation went on, asking the court for more and more money rather than just sticking with the amount for the case in chief. But I do think that the case law would have allowed us to do that.
Do you think that there's a potential for a chilling effect for parties who have been sanctioned and and attorneys who are partially on the hook from any attorney signing on to represent that party's interest? That seems a really potentially, dangerous consequence of us holding that. Look, once sanctions have been awarded, you're on the hook if you join in.
Justice Kavanaugh, I think the answer to that should be that if there's going to be a deviation from any attorney who steps into a case that was frivolous from the outset and had already been found to be frivolous in a hearing on the question of whether sanctions would issue. First of all, every attorney should obviously be very careful about entering into a case like that. But if there's going to be a deviation, it's going to have to be under the context of the language of the statute, which says that the prevailing party is entitled to their attorney fees for costs and fees in connection with the civil action, and it's against both the party and the attorney. And so if we're going to deviate from that, I think we would have to do so in a way that left that general requirement in place. And so I recognize the concern about a chilling effect, but I would also say that when you have a case as this one that's been found to be entirely frivolous, no one should have brought this case in the first, these defenses in the first place. And so the chilling effect, in a sense, Your Honor, is not all bad in that these arguments shouldn't have been being made. On the issue of an attorney stepping in and really trying to clean up a record, though, Your Honor, I think it would be possible to say that that person is not the attorney for purposes of frivolousness, but it would have to be very clear. And in this case, we don't have something like that. Again, we have the trial judge finding in its opinion in order that there was an attempt to relitigate issues that had already been settled, and that the way in which, Mr. Powers essentially inherited an indefensible case and handled it in a way that didn't kind of overcome that indefensibility. And the trial court, I think, was very clear about that in this case. And I think something that's worth considering is that I do think that it would be in the discretion of the trial court to treat the attorneys somewhat differently. There is a case, I think it's the Harrison case cited in the amicus brief, which has the Court of Appeals finding that one attorney was less culpable than another. Now, the main reason for that is because the attorneys had different information, and we don't have an issue like that in this case, where Mr. Powers stepped into a case knowing that the judge had already determined that the counterclaims and defenses, all of it brought by his client, Ms. Frye, was frivolous. So we don't have an issue like that here. I think you could justify a reading that has some ability for the trial court, because it's reviewed for abuse of discretion anyway. For the trial court to find a principled outcome that includes some kind of apportionment. But it should never be the burden of the prevailing party to determine what that apportionment should be, because you'd wind up getting into issues of attorney-client privilege. The prevailing party will never know which person on the other side of the V is most responsible for this action or that. And so if you're going to wind up pushing towards a direction where apportionment should be more normal, I don't recommend that. I don't think it comports to the text. But if you were going to do that, you'd have to be very clear, I think, that the prevailing party doesn't bear the burden of driving that litigation or of sorting out which attorneys or parties on the other side of the case is more responsible or less responsible for any.
Does the text take into consideration a situation where where everything that has been litigated and attorney fees being awarded, let's say there was one outstanding, or one issue that did have merit, and a new attorney comes in to just litigate that issue, and that's it. Everything else that they've abandoned, understanding that the attorney fees have been awarded based on that. Can that attorney be now looped into the attorney fees if they litigate an issue that is not frivolous?
So, Your Honor, I want to answer your question. I think scenarios like that are one reason why I've said in my brief that I don't think this case is an ideal vehicle to work through all of the issues that might be at play here. That's among other reasons. But I think that there's some possibility of that, but I'll say two things that I don't mean them to be contradictory, but I think there's considerations on both sides of that question. One is, I do think that there are federal cases which suggest that if a new attorney shows up and abandons every frivolous piece of a case, then that attorney should not be subject to sanctions. That's under different language. Rule 11 is very different from our frivolousness statute. And that's kind of the other consideration here, which is that the statute says that the party who prevails on the entire record is the prevailing party, and abandonment of previously litigated frivolous issues, I don't think takes you out of the language of the statute dealing with frivolousness in the first place. And the attorney, it still says that the attorney is to be responsible alongside the party. So I think that there might be some very factually intensive inquiries here that you might, again, find it to be an abuse of discretion or unreasonable for an attorney to show up and only, pick up the good part of a case and let the other parts go. But if you're going to go down that road, I think you just have to be very careful with the language of the statute, which suggests that if a party prevails on the entire record and there's been frivolous claims at any point in it, I think that the language of the statute most naturally reads that all of the attorney fees should be paid. And so if you were going to get into like an apportionment conversation at that point, I think it would make more sense than in a case like this one. But it would take some careful parsing because, and again, I think maybe some advocacy in a case where some features like that were present, because we don't really have any of that developed in this case.
Thank you.
Yes, ma'am. I mentioned a moment ago that Rule 11 and cases citing to Rule 11 in the amicus brief and in Mr. Powers' brief, I don't think are very helpful to this court for a couple of different reasons. The main one being that the standards are different. Rule 11 mostly looks more like MCR 1.109 E5 and 6, the signature verification requirements, whereas E7, which is the portion of the court rule that is at issue in this case, expressly is about frivolousness outside of the signature verification requirements. And so for that reason, I don't think the Rule 11 cases are terribly helpful. Similarly, cases that have fee shifting by virtue of the nature of the case, like a civil rights case or something along those lines, I don't think that those cases are really all that apt to analyze this case. But one issue that comes up in the context of those federal cases, in the Goodyear case, which Mr. Powers cites, is that the Supreme Court there said that the trial court had the inherent authority outside of any rule or statute. Is that my time, Your Honor?
It is your time. Yeah.
Thank you
Just
very
finish.
much. Oh,
Yep.
the trial court has the inherent authority to control its docket, to control its courtroom, and that reasonable sanctions comporting to the constitutional requirements for notice and opportunity to be heard are a part of that as well. And so I think we need to recognize that being essentially a federal common law ruling, we should understand that to be a part of our common law as well. Thank you, Your Honor.
Thank you.
May it please the Court, Barry Powers. To the extent that the trial judge was critical of my performance, I filed 2 motions, I made 2 motions, he granted both of them. So I was the prevailing party on those. So you can't hold me liable for something that the judge said was righteous. Second, there must be causation. Without a proper analysis and application of the principle of causation, to impose a fine such as this constitutes unlawful punitive damages. So the question for a successor attorney is he in a position to, quote, avert and correct an error that was made by his predecessor counsel? I was not in that position. Everything had been done. The case was done. So this is the exact same thing as in a tort case where the defendant stipulates to liability. He still has a right to a trial on damages. Even though Linda Frye may have stipulated to liability, that doesn't mean she didn't have a right to this evidentiary hearing.
Counsel, just a quick question. Do you feel this was reasonable? And if it was or was not, explain.
Well, in terms of my being held personally culpable for doing something, there was no standard by which I could have measured I didn't have a barometer. So you can't go into court and then post hoc be determined to have done something unprofessional or, a violative of some legal principle without giving a standard. So is my standard 109? No, I didn't sign anything. Is my standard 2591? No, it was not prosecuting a cause of action or defense to a cause of action. It was neutral. There was no prevailing party at the damages stage. I didn't lose anything. So I never failed to accomplish any objective on behalf of my client and did nothing to inflict any harm on the defendant or increase attorney's fees. So there being no causal link, even if I did a terrible job, no causal link to any exacerbation of harm, I don't understand how the rule or the statute can be construed in this way without violating the due process right to notice, the substantive due process right. Again, the vagueness of a standard of liability usually only applies in First Amendment cases, but the courts have said in a case such as this, it applies as well. So I can't go in there not knowing what my barometer is, other than what my ethics rules tell me, and I never signed anything, and I never prosecuted a cause of action or defense of a cause of action, and I never lost. I didn't not prevail. When you have a damages, well, I might say she should get $10,000 or $20,000, but just because my point, that doesn't mean we lost. It's not a cause or defense to a cause. And so I think that one thing about the amicus, I mean all due respect to the lower courts, but amicus called it perverse because what that means is any appellate attorney, which I was, who comes in to clean up the record, is if they're going to be entering into some sort of an unlimited possibility of fire and being put into the to the throes of penalty and losing their license, being cited by the Attorney Grievance Commission unilaterally, even though the client and attorney get along great, that drives a wedge between attorney and client. So I'm handling the appeal, and now I'm supposed to withdraw, and she doesn't get a right to an attorney. She's got to keep the old attorney she had.
Excuse
so
me.
there's so many practical difficulties.
Your time is up. Thank you. Thank you both. The case will be submitted.
Thank you.